Vi. The philosophy of law in the 19th century. In primitive society, an injured person may obtain redress by self-help, by the help of the gods or of their ministers, or in a limited class of cases and on compliance with certain procedural forms, by the help of the political organization. In antiquity, when the bond of kinship was the strongest bond in society, the first meant redress by the help of oneself and of his kinsmen, so that the staple institutions of primitive society are reprisals, private war and the blood feud. But these institutions are inimical to the social interest in general security, and so more and more appeals for redress are made to the state. Self-help and private war are regulated and repressed until the latter is wholly put down and the former becomes exceptional. Thus in its beginnings law is a means toward the peaceable ordering of society. It stands beside religion and morality as one of the regulative agencies by which men are restrained and the social interest in general security is protected. Moreover, this character of a regulative agency, of a means toward a peaceable ordering of the community, is retained to the end, although other purposes are added as it develops. In this first stage of legal evolution, men acquire the conception of a peaceable ordering of society through the peaceable adjustment of controversies. A second stage of legal evolution has been referred to in a former lecture under the name of the strict law. In this stage, law has definitely prevailed as the regulative agency of society, and the state has prevailed as the organ of social control. Self-help and self-redress have been definitely superseded for all but exceptional causes. Normally men appeal only to the state to redress wrongs. Hence the body of rules determining the cases in which men may appeal to the state for help comes to define indirectly the substance of rights, and thus indirectly to point out and limit the interests recognized and secured. When this point has been reached, two causes operate to produce a rigid system, namely, fear of arbitrary exercise of the power of state assistance to individual victims of wrong, and survival of ideas from primitive law when deliberate deviation from sacred texts and settled customs was held impious and dangerous. Accordingly, the chief end sought is certainty. The cases in which the state will interfere, the mode in which it will interfere, and the manner in which its interference may be invoked are defined in an utterly hard and fast way. The rules of law are wholly inelastic and inflexible. Also the law is highly formal. It refuses to look beyond and behind the form, for forms admit of no debate. At any rate, one may know whether the appointed form has been pursued. Thus the strict law is indifferent to the moral aspects of conduct or of transactions that satisfy its letter, and so further development becomes imperative. But the strict law gives us as permanent contributions the ideas of certainty and uniformity, and of rule and form as means thereto. A stage of liberalization, which may be called the stage of equity or natural law, succeeds the strict law. This stage is represented in Roman law by the classical period, the empire to Diocletian, in English law by the rise of the Court of Chancery and development of equity, in the law of continental Europe by the period of the law of nature school, that is, the 17th and 18th centuries. The watchword of the stage of strict law was certainty. The watchword of this stage is morality, or some phrase of ethical import such as equity and good conscience. The former stage insists on uniformity, the latter on morality, the former on form, the latter on justice in the ethical sense, the former on remedies, the latter on duties, the former on rule, the latter on reason. The capital ideas of the stage of equity or natural law are the identification of law with morals, the conception of duty and attempt to make moral duties into legal duties, and reliance upon reason rather than upon arbitrary rule to keep down caprice and eliminate the personal element in the administration of justice. Aside from liberalization of the law, the permanent contributions of this stage of legal evolution are the conception of good faith and moral conduct, to be attained through reason, ethical solution of controversies and enforcement of duties. But the endeavor to make law and morals coincide and to reach an ethical solution of each particular controversy gives too wide a scope to judicial discretion, so that at first the administration of justice in this stage is too personal and too uncertain. This excessive margin for discretion is corrected by a gradual fixing of rules and consequent stiffening of the legal system. Moral principles, having acquired the character of legal rules, are carried out to logical consequences until the original principle is lost among the derived rules, or are developed as mere abstractions and thus are deprived of their purely moral character. In this way transition takes place to the next stage, which may be called the maturity of law, as a result of the stiffening process by which the undue fluidity of law and overwide scope for discretion involved in the identification of law and morals are gradually corrected. There comes to be a body of law with the stable and certain qualities of the strict law, yet liberalized by the conceptions developed by equity or natural law. In this stage of mature legal system, the watchwords are equality and security. It derives the idea of equality partly from the insistence of the strict law that the same remedy shall always be applied to the same formal situation, and partly from the insistence of equity or natural law on treating all human beings as legal persons and upon recognizing full legal capacity in all persons possessed of normal mind and years of discretion. Hence its idea of equality has two elements: equality of operation of legal rules and equality of opportunity to exercise one's will and employ one's substance. It derives its idea of security from the strict law, but finds it modified by the ideas of the stage of equity or natural law that legal results should flow from will rather than from form, and that one person should not be enriched unjustly at the expense of another because of form and without intention. In consequence, its idea of security includes two elements: everyone is to be secured in his interests against aggression by others, and others are to be permitted to acquire from him or to exact from him only through his will that they do so, or through his breach of rules devised to secure others in like interests. To ensure equality, the maturity of law again insists strongly upon certainty, and in this respect is comparable in many ways to the stage of the strict law. To ensure security it insists upon property and contract as fundamental ideas. Our Bills of Rights bring this out in their guarantees of life, liberty and property. Liberty in such connections was taken to mean in the 19th century, and is still sometimes taken to mean, that the individual shall not be held legally unless for a fault, unless for an act on his part which infringes another's right, and that another shall not be permitted to exact of him except as and to the extent he has willed a relation to which the law in advance attached such power to exact. The same idea appears in the modern Roman law in the insistence upon will as the central point in legal transactions, and the 19th century attempt to make the Anglo-American law of contracts conform to the Roman conception was quite in accord with the spirit of the time. Along with liberty, the maturity of law puts property, that is, the security of acquisitions. But one of these acquisitions may be a power to exact from a promisor. Accordingly, contract acquires a property aspect. The law is regarded as existing to secure power of contracting freely and the right to exact a performance freely promised as widely as possible. Moreover, in this stage even personality acquires a property aspect. The power of the individual to make contracts freely is thought of primarily as a sort of asset. In other words, physical integrity and free motion and locomotion, physical and mental, are thought of as species of natural acquisitions, as it were, so that the security of acquisitions, which is conceived to be the main end of the law, includes 1. Natural acquisitions, that is, what nature has given one in the way of physical and mental powers; 2. What one has acquired through the position in which he found himself in society; and 3. What one has acquired through the free exercise of his natural powers. In the maturity of law men may be willing to agree that acquisitions of the second type shall be restricted greatly or even cut off for the future, but all idea of interfering with what has been so acquired in the past appears intolerable. From the point of view of this stage of legal development, Mr. Choate was entirely justified when he said, in his argument in the income tax cases, that a fundamental object of the law was preservation of the rights of private property. As I believe, the law has entered definitely upon a new stage, in many ways analogous to the stage of equity or natural law, as the maturity of law was analogous to the strict law. One may venture to pronounce as to the permanent contribution to the science of administering justice made by the period from which we are passing. Obviously its important legal institutions are property and contract. Its contribution seems to be the thorough working out of individual rights. Accordingly, the philosophy of law in the 19th century put individual rights at the foundation of the legal system. At the end of the 18th century, transition from the stage of equity or natural law to the stage of maturity of law was complete. On the continent, Codification had begun with the draft code of Frederick the Great in 1749, and in 1804 the French Civil Code summed up the work of the 18th century jurists and furnished the model for practically all the codes of the Roman law world until the Germans set a new model in 1896. In the common law world, Lord Mansfield had incorporated the law merchant in English law. Equity had crystallized so that in 1818 Lord Eldon could say that the principles of equity were almost as fixed and uniform as the rules of the common law and bills of rights in America were codifying the natural rights of man. The completion of this rigidifying process, which had been going on for more than a century, coincided with an epoch-making change in the philosophy of law. The theory of natural law had done its work of liberalization and modernization and had become for the time an agency of stabilization. Men thought it possible to discover a body of fixed and immutable principles, from which a complete system, perfect in every detail, might be deduced by purely logical operations, and held it the duty of the jurist to find them and of the legislator to promulgate the deductions in the form of a code. The principles also, they conceived, were to be discovered once for all by reason, since they were mere expressions of abstract human nature. They were the principles of reason inherent in the conduct of the abstract individual. But the possibilities of this juristic method had been exhausted. The rationalizing legal philosophy of Grotius had accomplished its task. It was no longer capable of making for growth in the law, and for a season growth was not needed. The demand of the time was not for growth but for system and classification and analysis in order to produce certainty and ensure security. Philosophy was asked to make law stable as 2 centuries before men had turned to it to make law fluid. Although 18th century natural law had led to codification and had become an absolute system, it was not equal to the philosophical problem of 19th century law. It left too much to the individual judgment and conscience to afford a satisfactory theoretical foundation. Indeed, the philosophical anarchist builds on the doctrine of natural rights and on the natural law conception of the individual conscience as the ultimate arbiter as to duties of obedience. The time was ripe, therefore, when the received theory of natural law got its death blow at the hands of Immanuel Kant. He undermined the 17th and 18th century foundations of philosophical jurisprudence and replaced them with a new order of ideas. These new ideas, however, were to serve for the basis of the stable law of the 19th century. Hence the present generation, wrestling with legal institutions and legal doctrines fashioned in other areas, often finds them entrenched, however remote their origin, in 19th century philosophy of law. To Kant and those who followed him more immediately, the first problem in law was the relation of law to liberty. He lived in an age of codification, an age of absolute governments, in which there was and it was taken that there had to be external constraint and coercion. But he lived also in the age of the French Revolution, a democratic age in which some other basis than mere authority was required to sustain the arbitrary and authoritative, the age of the classical economics, in which the individual demanded the widest possible freedom of action. Hence the problem was how to reconcile these two ideas, external constraint and individual freedom of action. This question furnishes the clue to all philosophical discussion of the basis of law in the last century. Kant met it by formulating what has come to be known by the significant name of legal justice, by working out the idea of an equal chance to all, exactly as they are, with no artificial or extrinsic handicaps. In other words, he put a new philosophical foundation under the idea of justice as the maximum of individual self-assertion, the idea which came in with the Reformation, and so enabled it to reach its final logical development in the law of the 19th century. Down to Kant, all jurists had been in agreement as to the method of legal science. Much as they might differ as to details, they were agreed in using philosophical method and in postulating a natural law by which all questions were to be tried. As the effect of Kant's demolition of the old natural law came to be felt, for a time philosophical jurisprudence was pushed to the wall, and it is only in the present century that philosophy has begun to regain the place it once held in legal science. The historical and the analytical methods are the methods of 19th century jurisprudence. This is true especially in Anglo-American juristic thought. English and Americans a generation ago were confident that they had effected a complete separation of jurisprudence from philosophy. To a certain extent, it is true, Such a separation took place everywhere, and we but carried it to an extreme. The need of stability and certainty in the maturity of law, and the importance of the social interests in security of acquisitions and security of transactions in a commercial and industrial society, called for analytical rather than philosophical method. The task of the jurist was to perfect what he found in the legal system rather than to build anew. Naturally, this general tendency of the last century became most pronounced in America since, as has been shown in another connection, American law is a product of the 19th century. Our classical period, from the Revolution to the Civil War, is not so much a period of growth as one of adaptation. It was not a creative period, but instead was a period in which received materials were worked over into better form and were developed into a consistent legal system. Hence, with all its appearance of growth, it was a period of stability, and in common with the maturity of law everywhere is comparable to the stage of strict law. For in each stage the law is taken to be self-sufficient. Such periods of legal development require and rely upon analysis rather than philosophy. It is in periods of growth, periods in which the law is fluid, periods in which an infusion of ideas from without is making over the law, that philosophy has played a leading role in legal history. Hence, on the one hand, philosophy of law is reviving today, as we enter upon the new stage of legal development which has been called the socialization of law, and hence, on the other hand, American law, the product of the 19th century, has affected to have no use for philosophy. In practical effect, the result has been to entrench in our legal thinking the absolute ideas which we inherited from the 18th century. The naive natural law of the practitioner, who takes the principles in which he has been trained and with which he is familiar for fundamental of all law everywhere. The theories of natural law and natural rights which came into our elementary books and our books on constitutional law from continental publicists of the 17th and 18th century had their own way with the profession, and later historical jurisprudence which developed a natural law of its own and reached results quite as absolute had its own way in the schools. Our absolute ideas which have prevailed so largely in American legal thinking come from Grotius in two ways. On the one hand they come through Blackstone, whose preliminary discussions are founded upon Grotius, and on the other hand they come through American publicists in the 18th century and the first part of the 19th century who followed the Dutch and French publicists and civilians. Chiefly, however, they come from Blackstone. It was only in the present generation that legal education in the majority of our best schools was divorced from Blackstone, and bar examinations in many states still call for a knowledge of this obsolete legal science. Such was the result in practice of our contempt of philosophy of law. Two movements are represented in 18th century juristic thought. First, there is a purely juristic movement, proceeding upon the conception that law is reason, in which the ideas of right and justice are made paramount. In this movement, as we have seen elsewhere, individual rights and justice as the realization of individual rights were put above state and society as permanent absolute realities which state and society existed only to protect. Second, there is a legislative movement in which rights are thought of as the product of the human will, as the outgrowth of a social contract, so that there would be no rights without the social organization and no justice or law but for the political organization, a movement in which law is thought of as emanating from the sovereign and the idea of command of the state or of the general will becomes paramount. Both theories are stated by Blackstone without a hint of their inconsistency. In the 19th century, however, they came to divide the field. The second theory passed into political thinking and the science of legislation. Thence, following Bentham, it was taken up by the analytical jurists, who have been dominant in English legal thought since the middle of the last century. But this side of analytical jurisprudence was never congenial in America. The first theory passed into metaphysical and historical jurisprudence, already accepted by the American lawyer, while analytical jurisprudence was formative in England. It came back to him presently in scientific garb from Germany and became a settled conviction. 5 types of philosophy of law in the 19th century are of significance for our present purpose. We may call those who adhered to them the metaphysical school, the historical school, the utilitarians, the positivists and the mechanical sociologists. It is a striking example of the way in which the same conclusion may sustain the most divergent philosophical premises, that all of these arrived ultimately at the same juristic position by wholly diverse routes and from the most diverse starting points. So that the futility of conscious effort to improve the condition of humanity through the law and the conception of justice as the securing of the maximum of self-assertion became axioms of juristic thought, while to the 18th century justice meant the securing of absolute, eternal, universal natural rights of individuals. Kant held that it meant securing freedom of will to everyone so far as consistent with all other wills. The metaphysical jurists developed this idea. Their fundamental position was that the whole legal system could be deduced from the conception of right, and in this way a critique of institutions and doctrines, a sort of ideal system, could be set up. As a rule they carried out Kant's idea of securing the free will into its practical consequence of liberty, of general freedom of action for individuals. Hence in their view the end of law was to secure widest possible liberty to each individual. The test of right and justice with respect to any institution or doctrine was the amount of abstract individual liberty which it secured. The metaphysical method gradually fell into discredit abroad after the middle of the 19th century, although it had representatives in juristic writing to the very end of that century. But through its effect upon the historical school, which controlled legal thought for almost 100 years, its intensely individualist conception of justice governed in jurisprudence until the rise of the social philosophical school set jurists to thinking in a new way. Anglo-American jurists paid little or no attention to the systems of the metaphysical school. Its central idea of liberty, however, fitted the 18th century individualism of our law so well that the method of deduction from that idea was gradually adopting when a new and more attractive mode of getting to the same result was furnished by the positivists. Savini, the founder of the historical school, turned Kant's formula of right into one of law. Kant thought of right as a condition in which the will of one was reconciled with the will of another according to a universal rule. Savini thought of law as the body of rules which determine the bounds within which the activities of each individual are secured a free opportunity. If we adopt an idealistic interpretation of legal history and conceive of the development of law as a gradual unfolding of Kant's idea of right in human experience of administering justice, we shall understand the position of the historical school. For Savini carried forward one of the two ideas which had been contending in jurisprudence in the 18th century. The element in law which the medieval jurists had rested on theology, the 17th century jurists had derived from reason, and the law of nature school in the 18th century had deduced from the nature of man. Savini sought to discover through history. In effect, the historical school and the metaphysical school were closely akin. Each postulated an ideal law. One sought to discover this ideal law through history, the other sought to find it through logical development of an abstract idea. Indeed, it was not hard to reconcile these views. As the historical jurists adopted the idealistic interpretation of legal history, it was possible to say that jurisprudence had two sides. On the one hand, it had to do with the historical unfolding of the idea of liberty as men discovered the rules by which to realize it. This was historical jurisprudence. On the other hand, it had to do with the logical unfolding of the principles involved in the abstract conception. This was philosophical jurisprudence. Most of the German expositions of jurisprudence in the latter half of the 19th century proceed in this way. Philosopher and historian were agreed that law was found not made. One found it by deduction from a metaphysical principle, the other found it by historical study. Each, one need not say, found an ideal development of the principles of the existing law. The historian because he so interpreted history, the philosopher because he was seldom a lawyer and got his facts and illustrations from the historian. The doctrines of the German historical school appear to have been taught first in this country in a course of lectures given by Luther S. Cushing at the Harvard Law School in 1849 and published in 1854. It is interesting to note that the late James C. Carter was a law student at Harvard the last year that this course was given. For unless the effect of early training is borne in mind, it is hard to understand how a jurist of his caliber could dogmatically assent to Savini's views in 1905. But the influence of the historical school did not become marked in America till after 1870. When American students had begun to go to Germany in increasing numbers and German ideas had taken root in our universities. In the meantime, another influence had profoundly affected American legal thought. That influence, namely, the political interpretation of legal history and political theory of jurisprudence expounded by Sir Henry Maine, moved in the same direction. I have spoken sufficiently of Maine's political interpretation in other connections. It is enough to say here that his theory of the progress from status to contract was so thoroughly adapted to the individualism which characterized the traditional element of our law for other reasons and accorded so well with the absolute ideas which our law books had inherited from the century before, that it soon got complete possession of the field. As I have said, the historical jurist and the philosophical jurist agreed that law was found, not made, differing only with respect to what it was that was found. The philosophical jurist thought that a principle of justice and right was found and expressed in a rule. The historical jurist conceived that a principle of human action or of social action was found by human experience and was gradually developed into and expressed in a rule. Hence the historical school denied that law was a product of conscious or determinate human will. They doubted the efficacy of legislation, in that it sought to achieve the impossible and to make what cannot be made. They held that the living organs of law were doctrinal writing and judicial decision, whereby the life of a people, expressed in the first instance in its traditional rules of law, made itself felt in a gradual development by molding those rules to the conditions of the present. I would not be understood as denying or forgetting that this historical school did many great things for the science of law, but its exclusive reign in American juristic thought in the past 50 years brought out its worst side. For the historical school also worked a priori and gave us theories fully as absolute as those of the school of natural law. Each deduced from and tested existing doctrines by a fixed, arbitrary, unchangeable standard. When the historical jurists overthrew the premises of the philosophical school of the preceding century, they preserved the method of their predecessors, merely substituting new premises. They were sure that universal principles of jurisprudence were not to be found by deduction from the nature of the abstract individual. But they did not doubt that there were such principles, and they expected to find them through historical investigation. In the United States we carried this further than elsewhere, since the merger of the common law rights of Englishmen in the rights of man seemed to show that here at least universal principles had been worked out in the course of legal history. Even now, on the whole, the basis of all deduction is the classical common law. No system of natural law was ever more absolute than this natural law upon historical premises. For other systems of natural law gave ideals developed from without. With us, under the dominion of the historical school, the sole critique of the law was to be found in the law itself. Moreover, every addition or amendment from without was brought to the same test. As late as 1905 a leader of the American bar, thoroughly imbued with the ideas of the historical school, told us that it was a wise doctrine to presume that legislators intended no innovations upon the common law, and to assume so far as possible that statutes were meant to declare and reassert its principles, as no statute of any consequence dealing with any relation of private law can be anything but in derogation of the common law. The social reformer and the legal reformer, under such a doctrine, had always to face the situation that the legislative act which represented the fruit of their labors would find no sympathy in those who applied it, would be construed strictly, and would be made to interfere with the status quo as little as possible. Dring tells a story of a professor to whom a question of commercial law was submitted. He returned an elaborate and thoroughly reasoned answer based upon the principles of the Roman law, the basis of the common law of continental Europe and hence of legal instruction. Upon suggestion that he had omitted to notice a section of the commercial code which appeared to govern, he responded that if the commercial code saw fit to go counter to reason and the Roman law, it was no affair of his. Surely we may sympathize with the learned professor, for under the influence of a taught traditional law and of a historical school of jurists which scouts legislative lawmaking, we proceed in much the same way. Our text writers will scrupulously gather up from every remote corner the most obsolete decisions and cite them diligently. but they seldom cite any statutes beyond those landmarks which have found a place in our common law. When they do refer to statutes, it is almost always solely through judicial decisions in which they are construed or applied. Nor will it do to say that this is justified by the instability of our legislation. Unstable as some of it is, much of it is thoroughly stable, while much of our case law is unstable. It is not that the statutes are unstable. It is rather that the reader will not be interested in them. He does not feel that they are law in the same sense as an adjudicated case. He does not want to cite them if a case may be had in which the portions of the statute applicable have been incorporated. Accordingly, it is natural that courts, even where they do not actually hold important legislation to be merely declaratory of the common law, too often make it declaratory in effect by citing prior judicial decisions and assuming that they expressed the rule enacted by the statute. In this way, much of the work of uniform state legislation upon commercial subjects is threatened with undoing. While the metaphysical jurists were deducing the whole system of rights and the idea of the end of legal systems from a metaphysical conception of liberty, another school of jurists was seeking a practical principle of lawmaking. The metaphysical school was a school of jurists. Its adherents had their eye upon the law as a whole, upon systems which had come down from the past, and they sought the principles upon which such systems and their doctrines might be criticized and their further development might be directed. The English utilitarians, on the other hand, were a school of legislators. While the metaphysical jurists sought principles of criticism of what was, they sought principles of constructing a new body of law. The founder of the utilitarians, Jeremy Bentham, took law reform for his life work. As a practical principle in his work of law reform, he took what he called the principle of utility, namely, does the rule or measure conduce to human happiness? His one principle of criticism was, how far does a rule or doctrine or institution conduce to or promote human happiness? This criterion might well have been used to break down the individualist idea of justice. At this time, however, the age of Adam Smith and the great economists, individualist ideas were too firmly fixed in men's minds to be questioned. A criterion of the greatest good of the greatest number possible, of that which serves for the happiness of the greatest number used as the measure of the conduct of each, would not be far from some recent ideas of justice. But Bentham did not question individualism. He vacillated between utility in the sense of the greatest happiness of the individual and in the sense of the greatest happiness of the greatest number. Perhaps as near as he came to a choice was to assume that the greatest general happiness was to be procured through the greatest individual self-assertion. Accordingly, his juristic principle was not unlike that of the metaphysical jurists. Everyone, he held, is the best judge of his own happiness. Hence legislation should aim at a removal of all those restrictions on the free action of an individual which are not necessary for securing the like freedom on the part of his neighbors. It will be seen that practically Bentham's principle was to permit the maximum of free individual action consistent with general free individual action. In effect, his conception of the end of the law was the same as that of the metaphysical school, to secure the maximum of abstract individual self-assertion. This fitted entirely with the inherited individualism of common law lawyers. Bentham and his immediate disciples believed in legislation. They left their mark upon Anglo-American law through the legislative reform movement of the first half of the last century, of which they were the promoters. But this reform movement was not a creative one. In many ways it was analogous to Justinian's legislation in the maturity of Roman law. It carried out to formal and logical fruition ideas which had achieved their maturity in a prior stage of legal development. Bentham's legislation was a pruning away of archaisms, a removal of shackles upon individual activity which had come down from the Middle Ages, and a stating of the law in a more accessible and intelligible form. This conception of legislation, coupled with Bentham's interpretation of utility as requiring a minimum of interference with the individual, led the next generation of English utilitarians to the same position as that of the historical school. They came to agree that legislation except in emergencies and for certain incidental purposes was an evil. The historical school said it was an evil because it attempted to do what could not be done. namely to make law consciously. The newer utilitarians said it was an evil because that government governed best that left men most free to work out their own happiness. Bentham had already put security as the main end to which the legal order should be directed. Taking this to mean security in the maximum of individual self-assertion, a sort of juristic pessimism was developed, a doctrine that we can do no good by law, we may only avert some evils. Equality, says Morkby, one of Bentham's later followers, may be hindered by the law, it cannot be promoted by it. In the last 2 decades of the 19th century, the juristic ideas on which metaphysical jurist, historical jurist and utilitarian were agreed appeared to be confirmed from a new quarter. Although in common with sociology, sociological jurisprudence has its origin in the positivist philosophers, in the sense that each has a continuous development from Comte's positive philosophy. Its development has been determined rather by the social philosophical school which rose from the breakdown of the metaphysical and historical schools on the continent. At first, however, the positivist philosophy of law and the so-called sociological science of law were in their way quite as absolute as their rivals. Comte thought of the universe as governed by mathematical mechanical laws, and hence of moral and social phenomena as so governed. The next generation of positivists, influenced by Darwin, thought of evolution as governed by inexorable mechanical laws. Accordingly, the positivist or mechanical type of sociologist sought for absolute mechanical social laws whose inevitable operations produced all social, political and jural institutions, as completely apart from human will as the motions of the planets. The positivist jurists sought to find laws of morals and laws of legal and social evolution analogous to gravitation, conservation of energy and the like, and they expected to find these laws through observation and experience. But observation and experience led them to the same result to which metaphysics had led the philosophical jurists and history had led the historical jurists. For one thing, they got their data from the historical jurists and so looked at them not independently but through the metaphysical spectacles of that school. Moreover, like the whole century, they were subconsciously under the influence of Kant. Kant had become a part of the thought of the time so thoroughly that all 4 of the 19th century schools came to his position as to the end of the law, though for different reasons and in different ways. Thus the views of the positivists were congenial in jurisprudence and were especially congenial in America. Spencer's writings had great vogue in the United States, and many cases where judicial decisions show the effect of his ideas might be cited. Accordingly, mechanical sociology lingered in American juristic writing longer than elsewhere because its ideas appeared to confirm those of the historical school. Many who were beginning to be conscious that the historical school could not hold the ground much longer were able to flatter themselves that they were moving forward by giving to their old views a new form of mechanical sociology. Like the historical jurist, the mechanical sociologist of the end of the 19th century looked at law in its evolution, in its successive changes, and sought to relate these changes to changes undergone by society itself. The historical jurist found metaphysical laws behind these changes. The mechanical sociologist substituted physical laws. For all practical purposes the result was the same. This is true especially of the type which has had most vogue in America, namely, the phase of the mechanical sociology which identified with economic laws these supposed mechanical laws which absolutely determine the content of legal systems. It is not too much to say that this combination of the economic interpretation with positivism gave rise to a sort of fatalist natural law. The old natural law called for search for an eternal body of principles to which the positive law must be made to conform. This new natural law called for search for a body of rules governing legal development, to which law will conform do what we may. The operation of these same rules will change it and will change it in accordance with fixed and definite rules in every way comparable to those which determine the events of nature. The most man may do is to observe and thus, it may be, learn to predict. For the rest nature will take her inexorable course and we may but impotently wring our hands. If law is an inevitable resultant, if in making it or finding it, legislator or judge is merely bringing about conformity to the de facto wishes of the dominant forces of the community, conscious effort to improve the law can be effective in appearance only. The 18th century theory, even if it put the basis of legal systems beyond reach of change, moved us to scan the details and to endeavor to make each part conform to the fixed ideal plan. It admitted that legislator and jurist had each a function. The historical school denied any function to the legislator. It said law could no more be made than language. Each was a growth upon the basis of a received tradition. The positivist economic interpretation denied all function to the jurist. To the doctrine of legislative futility, which the historical school had fastened on our teaching, it added a doctrine of juristic futility. It is no wonder that a generation of lawyers trained in 19th century philosophy of law has been slow to respond to the modern faith in the efficacy of effort. At the end of the last century, the rise of the social philosophical jurists, and in the last 2 decades the development of a sociological jurisprudence which has definitely rejected absolute ideas, produced a new legal science on the continent, and its ideas are slowly taking root in Anglo-American thought. But as I shall endeavor to show in a subsequent lecture, the good sense of courts has led to a movement beneath the surface in judicial decision which has been in advance of our thinking and teaching. Hence I used to suggest, when the recall was agitating, that our impatient reformers should demand, not recall of judges or of judicial decisions, but recall of law teachers and of juristic thinking. Certainly our busy courts have had much more excuse for being out of touch with recent social and political and economic science when we reflect that everything scientific which was accessible to them in English served to confirm the ideas in which judges had been brought up. We must recall much of the jurisprudence of the last century. And yet the juristic thought of that time was not wholly in vain. It may teach us that there are inherent limitations on what may be achieved through law, and inherent limitations upon the efficacy of effort in conscious lawmaking, that for the greatest part law must always be found through application of reason to causes as they arise and the testing of principles in their actual operation, that laws are not like clothes to be thrown off and replaced at will, but, like language, are so intimately a part of all we do that development of the traditional materials will always be the chief agency of growth. Used to temper the enthusiasm of a new period of liberalization, the philosophy of law of the last century may yet save us from the excesses of the stage of equity and natural law, a reaction wherefrom had so much to do with the rigidity of the law under which we live.